Hello, and welcome to another edition of ABI Podcast. I'm Professor Drew Dawson of the University of Miami School of Law, and I'll be your host for this episode. My guest today is Ken Epstein, an investment manager and legal counsel at Bentham IMF. Ken has extensive experience in bankruptcy and financial restructuring, which he brings to bear in leading Bentham's investments in bankruptcy and insolvency-related matters. Thank you for joining me today, Ken.
My pleasure. Thanks for having me.
Now, before we get started, I do want to remind our audience that nothing we say here today is intended to provide legal advice, and that the opinions that we are going to express today in this conversation are our own personal views and not necessarily those of the institutions that we represent. Ken, to get us started, can you talk to us about your firm, Bentham IMF?
Yeah, so Bentham IMF is the U.S. subsidiary of IMF Bentham, which is an Australian company listed on the Australian Securities Exchange. IMF Bentham pioneered the modern litigation finance market in Australia about 20 years ago and went public in 2001. And we opened the U.S. branch, Bentham IMF or Bentham Capital, in 2011 and have been growing ever since.
For those of us uninitiated to the litigation finance world, can you give us an overall idea of what you mean by, commercial litigation finance and how this works?
So with commercial litigation finance, a third party unrelated to a lawsuit provides capital to a plaintiff involved in litigation in exchange for a portion of the financial recovery from the lawsuit. Commercial litigation finance is between sophisticated parties and typically involves complex, lengthy, and expensive litigation. And our investment, and I want to distinguish that it's an investment and not a loan, is being provided on a non-recourse basis. So to the extent the litigation is successful, we get our return. To the extent that the litigation is not, then there's no obligation on the part of the litigant to repay us.
And when you said these are investments, as I understand it, there's different sort of investment products that commercial litigation financiers provide. Can you talk to us? What are the different types of products do you offer?
We typically provide funding in a couple of different ways. One is on an individual case basis. So to the extent a litigant has limited resources but a meritorious claim, then we can provide for the payment of all or a portion of that litigant's fees and expenses. That's one way. So there's a way to invest on an individual case basis. And then separately, we have what's called a portfolio investment approach, where if there are multiple causes of action, we can cross-collateralize our investment. And this option is often used by law firms who take matters on contingency, or on the client side, if a client has multiple plaintiff side actions that it wants to bring, but for whatever reason, either doesn't have the capital to bring them or doesn't want to bear the entire risk associated with the litigations.
So can you mention that sort of two basic types of litigation finance products, sort of the law firm side and the client side? Can you go in a little bit more detail? What is the client-side litigation funding, and how could that be beneficial to a trust estate, a debtor, to creditors?
This is one of the areas that I'm really excited about, and it is a way that our product can be used to increase recoveries to trust beneficiaries and the like. And just like when you have a law firm portfolio financing and you can group together 3 or more litigations to collateralize our investment, the same is true on the client side. So if you have a trust that's set up and that trust is the transferee of multiple causes of action, let's say that the trustee post-confirmation holds 2 preference claims and 2 fraudulent conveyance claims and a claim against an insurance company that has been disputed coverage, or tax claims and recovery claims and things like that. It's possible to get an investment from us that is cross-collateralized by those multiple actions. And let me give you an example of how it works out to the benefit of the estate. So if you assume, say the trust has 5 causes of action and the estimated damages are $100 million, and it's going to cost $5 million to secure that recovery. So you have, again, 5 causes of action, cost $5 million to recover $100 million. And the trust otherwise has no resources to litigate. Then the trustee has 2 options primarily. One is it can hire contingency counsel, or it can get litigation funding, get funding from another source. If you hire contingency counsel, typical arrangements are 40% of the litigation proceeds or something like that. So in that instance, you have a recovery of $100 million, the lawyers get $40 million, and the trust estate gets $60. So $60 million is distributed out to trust beneficiaries. And of course, we're using simple numbers. We're not talking about other leakage and administrative expenses and all that kind of stuff, but just to keep it simple. If you take funding on that same example and cross-collateralize it, where you can pay a return on the deployed capital as opposed to the litigation proceeds, then let's say your agreement with the funder is to return 3 times their money. The estate in that context, assuming the same facts, 5 causes of action, $5 million to secure the recovery, and legal fees, and $100 million recovery, the estate gets $85 million out of that as opposed to 60. The funder gets $5 million, its deployed capital times 3, so $15 million back, and the remainder goes to the estate. So again, in the kind of portfolio case, especially in the trust environment, I think it can be extremely beneficial as opposed to some of the other alternatives. And of course, there are ways to combine and use a hybrid approach between contingency and litigation funding, perhaps, to achieve even greater results.
And how do the borrowers end up using these products, either on the client side or the law firm side? You hinted the law firm side, it's a sort of an alternative financing for contingency-related matters that might otherwise be handled through contingency fees.
Correct. Yeah. So on the law firm portfolio side, if a law firm has 3 or more matters that it has taken risk on, then they can work with us and we can provide them financing that is cross-collateralized by those matters. And it looks more like a traditional line of credit than our single case financing, which is done on an individual case basis. And the return in that case is usually based on a multiple and of the deployed capital, and is not tied to the recovery on any one individual case. And our relationship is with the law firm as opposed to directly with the client or the claimant in most of our individual funding scenarios. And you asked how it can be used. It can be used in a number of different ways. In particular, in the bankruptcy context, it can be used by debtors, creditors, trustees, receivers, anybody who has a litigation claim that it controls and either doesn't have the resources to bring it or wishes to share some of the risk associated with the litigation. And so we have seen in a number of contexts, just take, for example, a post-confirmation trust that's set up after a company emerges from bankruptcy, where the claims that are held by the creditors or the debtors pre-confirmation are transferred to this trust. And a trustee has limited resources potentially to prosecute valid causes of action. And so that trustee or receiver or plan administrator, as it's called, can use our funding to help level the playing field against well-heeled defendants that would otherwise be able to use the advantage of their greater resources against the trustee.
Absent the availability of commercial litigation finance, think of that. Talking about that liquidating trust. That what would, absent the availability of this sort of financing, what means would the trustee otherwise have to pursue those causes of action?
It really depends on the situation. So if a trustee, oftentimes when a trust is set up, it may be set up with some seed funding that is provided by the debtor or the secured creditors under a plan. If the trust has the ability to sell an asset very quickly, then it may be able to self-fund. That may not be the case in most scenarios. Or they can try to go out and get a more traditional loan or line of credit backed by assets to the extent they exist in the trust. If those kind of more traditional sources of capital are not available, then they have a couple of options. One is to find a contingency law firm to help represent them, in which case that firm would take a piece of a percentage of the ultimate litigation recoveries. Usually, I think it's about 40%. Or they can come to a funder, which is a rather new option and becoming more widespread and available to obtain money to prosecute the actions in a similar fashion. And with litigation funding, they can choose from a broader pool of law firms, those that they could pay hourly or on some hybrid model, and also use the funds for a lot of different purposes. So it doesn't have to be limited necessarily to just prosecuting the lawsuit. They can use funds for the administration of the trust or a liquidity event to pay out trust beneficiaries, potentially to investigate claims, and all different types of stuff.
So in some ways, it sounds like one helpful way of thinking of litigation funding in the bankruptcy context is perhaps as competing with law firms who might otherwise be offering their services on contingency, maybe competing with other parties in the case who might actually have an interest in financing this. Or my misunderstanding is perhaps it's more nuanced and occasionally actually working together. It's more of a cooperative approach between more traditional lenders, traditional means of financing litigation, along with these sort of newly available financial products.
I wouldn't describe it that we compete with contingency lawyers, because oftentimes we can work together in concert to obtain the best result for the client. For example, many contingency law firms, while they may be comfortable taking the risk associated with the litigation and investing their fees, may not want to pay out the costs associated with the litigation. So retaining experts and advisors and things like that are critical to the successful outcome of the case, but they may not have the resources or desire to pay that out. So oftentimes, in large litigations, even if you see a contingency law firm there, we will provide for the payment of costs and expenses to enable the lawsuit to go forward. We can also provide working capital to a litigant, which is critical, especially for contingency firms, to alleviate some of the pressure that may exist and the litigant may feel to settle. So, the goal is to have a case decided on its merits, as opposed to guided by the resources that are available to the defendant versus the plaintiff. And our funding really does help level the playing field. So to answer your question, there is a natural way that litigation funding and contingency counsel can work together on a case, I think, to achieve the best outcome.
Great. And I'm curious about other examples where litigation funding could benefit parties in a bankruptcy matter, whether that's the debtor or the creditor. The litigation trustee seems like the most obvious fit,
Sure.
But as I mentioned in the introduction, you bring a whole wealth of experience as a former bankruptcy lawyer, as a managing director in the restructuring and remediation group at a large financial firm. So, based on your experience, who exactly can benefit from commercial litigation funding in this bankruptcy context?
It's really kind of exciting because we're just figuring out as an industry, how to use this product effectively in the bankruptcy context. And there's a lot of different ways. So, like you said, the most obvious way perhaps is when you have a litigation trust set up whose sole purpose is to litigate and get recoveries into the estate. That's an easy one. But and it has been used. Litigation funding has been used in a number of times for that purpose, and there are a number of cases where we could point to where bankruptcy courts have blessed that, and it has really worked out well for the litigants. And we can come back to that, but in other aspects of a bankruptcy case, it can work as well. So we are looking at a case right now where there's a debtor that is on the verge of filing for bankruptcy, and its primary asset is claims that it has against third parties. And absent other hard assets from which to get a DIP loan, it may not otherwise be available to get financing from a traditional source. So we're evaluating the underlying strengths of the claims to see whether or not we can provide DIP financing to that client. And then on the exit side, we looked at a deal very recently where a case was borderline administratively insolvent. The law firm, was invested in the case, as was the advisors, and they were looking for a way to de-risk themselves in part and provide for financing for the post-confirmation reorganized debtor to pursue claims. And so I think that there are ways that financing can be used both on the entry point and the exit point in bankruptcy, depending on the situation. Now, we can't compete on economics generally with traditional sources of capital. Our return is much greater because the risk is a lot greater and we're non-recourse than a bank that's going to provide DIP financing on a large company that has assets that it can get a priming lien on. But if you have a situation where the company has litigation assets that need to be monetized or that people want to de-risk a portion of, then we can come in and provide a very competitive alternative.
That's really interesting. It'd be interesting to watch this develop. One question I have, though, is, even if we are going to stay in more the sort of the bread and butter of litigation finance, we're thinking about litigation trust. Even in that context, although it may look very much like commercial litigation funding outside of bankruptcy, the mere fact that it's happening in bankruptcy raises some interesting and challenging issues. What are some of the bankruptcy special aspects of funding, even more of a traditional litigation trust?
Yeah, so that's a really good question, and the bankruptcy practitioners know that in the bankruptcy context we have greater transparency and disclosure by necessity to bring the entire process into light and add legitimacy to it. So whereas typically litigation funding agreements are confidential outside of bankruptcy context, subject to disclosure by the client and agreement with the funder, which does happen from time to time, in the bankruptcy context, it is likely, at least pre-confirmation, that there will need to be disclosure of the agreement. And whether the type of disclosure and the method of getting the court's blessing, I think, will depend in part on the type of financing that's being sought and when. So it is, in most of the cases that I've seen that have dealt with this, the financing agreement, at least the salient terms and the nature of the competitive process that has gotten folks comfortable with that, has been disclosed to the court, and it's been on notice and motion and has been approved by the court. And that's for the comfort of all of those parties involved. And again, to add to the legitimacy of the process. So just for example, in the General Motors case, there were 2 rounds of funding. The first one, the government ended up funding it at a no interest loan. And then the second round, a third-party litigation funder ended up funding it. And that was, the agreement was structured as a capital provision agreement and was brought pursuant to Section 364 of the code, just like a traditional DIP loan would be or a financing agreement would be. And it was approved by the court. And the funder went ahead and funded the case. A lot of people are familiar with that case. And that was done primarily under 364 because it was structured more like a loan. There's another recent case where funding has been used that's been well publicized, and that's the MagCorp case. And Lee Buchwald, as a trustee there, had this kind of innovative idea. And he said, we have this 14 years of litigation. We have a judgment now that's now up on appeal, and the trust is running out of money. And how can we, our client, de-risk, number one, de-risk and make sure that we're going to have something to pay out the creditors in the event we lose the appeal, and two, provide additional resources to litigate the appeal and whatever else comes next. So what he did was he ended up selling a piece of the judgment to a third-party litigation firm in exchange for a return, and that was teed up more like a sale. So that was teed up under 363, which had a competitive bidding process and a breakup fee, et cetera, because it was more like selling an estate than it was more like a financing agreement. So, the bankruptcy aspects of this are important, and it kind of highlights the need to work with a funder that is familiar with that and to work with, a law firm that knows how litigation financing works and how the bankruptcy process works.
Yeah, it's an interesting issue, especially like the MagCorp scenario where you're effectively selling off. The trustee is effectively selling off an estate asset, right? At which point we maybe have two concerns. The importance of transparency. One is, are you selling it for a fair price? And I suppose the second is the issue of when selling off part of the claim, does that third-party litigation funder then have some control over the trustee's decision whether and how to settle or pursue that claim?
Yeah, that's a great segue to a critical issue and a common misconception among folks about litigation finance. So in the U.S., litigation funders, at least to my knowledge, at least as it relates to Bentham, do not take control of the litigation, and they are, in many cases, restricted in the type of control that they could potentially take by laws governing, an ancient doctrine called champerty and maintenance. But more fundamentally, litigation funders cannot intermeddle in cases, and the funding agreements are and should be kind of carefully drafted to limit the types of control that a funder can exert. So in our Bentham's litigation funding agreements, for example, we spell out with great detail the type of communications that we have with the client and what we can and can't do. So we do not control case strategy. We don't control choice of counsel, and we don't choose when, and we can't say when a litigant should settle or go to trial. All of those things are part of the risk that we agree to take on in having some lack of control. And that is all prescribed in the funding agreement, and clearly something that a party seeking litigation finance should look at very carefully. Now, you highlight a distinction in the bankruptcy context where you have a trustee or someone else who has a fiduciary duty to creditors. And so it raises the importance potentially in that context, and even more reason why bankruptcy is a great way to proceed with litigation finance, because you do have disclosure and everyone has a chance to make sure that whatever consultation rights or information rights the funder has, it doesn't go too far towards the spectrum of control.
Super interesting, and I be interesting to watch the growth of this industry and the impact this is going to have on both commercial litigation broadly, but especially in the context of bankruptcy. Mm-hmm. Well, that's about the end of our time here. Thank you again, Ken, for joining me, and thank you to all our listeners for tuning in. Please remember that you can access ABI's archive of over 200 podcast episodes in the ABI online newsroom. Until next time, this is Drew Dawson, and thank you for listening to this edition of ABI Podcast.